Do you hear me though? Do you hear me? Welcome to the official launch of the Law, History, and Politics with MsAnalytical channel. So this is the channel that I will be discussing all things and all matters pertaining to law, history, and politics. Okay? Here we go. Hey guys, it's your girl MsAnalytical, and this is the very first episode of my new channel, which I'm going live not just on Spreaker, but I'm also live on YouTube while I'm literally talking to you all. So you can hear this commentary live right now. I posted the link on my main channel, so you can head over to the Law, History, and Politics with MsAnalytical channel, and I'm going to be reading the documents pertaining to this case. Now, a lot of people don't know this though, but this libel suit was filed March 21st of 3 years ago. And this case is literally been back and forth for 3 years. Now, we all know that there was a countersuit, but the countersuit was pretty much failed on Tasha's part because she wasn't able to produce enough documents pertaining to the $3 million that she countersued for. So the countersuit was the first one, and it was dismissed. And I believe rightfully so. But this is the original documents of the case that's now in court. And this is the one that involves Cardi B as the plaintiff and Tasha K as well as Star Marie Jones as the defendants. Now, I'm going to get to Star Marie Jones later on because I've been really trying to figure out why she hasn't been had a representative of the law in the court. And I saw something from Sean Davey Way, and he's explaining it. He's giving a theory, but I'm going to get to that towards the end. So here it goes. It reads, and this is 30 pages of documents. It reads, the United States Court, Northern District of Georgia, Atlanta Division. And it's public records, okay? It reads, Belcalis Malenis Almánzar, plaintiff versus Latasha Transrena Kebe, a.k.a. Latasha Transrena Howard, and Star Marie Ebony Jones, defendants. Complaint and demand for jury trial. Plaintiff Belcalis Malenis Almánzar, plaintiff, for her complaint against defendants Latasha Transrena Kebe, a.k.a. Latasha Transrena Howard, in quotations Kebe, and Star Marie Ebony Jones, in quotations Jones, collectively, in quotations defendants, alleges as follows. 1. The nature of the case. Part 1. This is a diversity action asserting Georgia state law claims for slander per se, libel per se, defamation, and invasion of privacy, false light as a result of defendants' publication of slanderous and defamatory statements regarding plaintiffs that are false, harmful, and offensive to the plaintiff. Parties. 2. Plaintiff is a citizen and resident of the state of New York. 3. Upon information and belief, Kebe is a citizen and resident of state of Georgia who resides at an address in Southwest Marietta, Georgia, 3008. So she lives on Jana Lane, Southwestern Marietta, Georgia, 308. I'm not going to read the building number, the house number. Upon information and belief, Jones is a citizen and resident of the state of Georgia, as she resides at Danforth Way, Stone Mountain, Georgia, 387. Jurisdiction and venue. The court has jurisdiction over the subject matter of this action pursuant to 28 U.S.C. Code 1332, as this is an action between plaintiff, who is a citizen of the state of New York, and defendants Kebe and Jones, who upon information are belief are citizens of the state of Georgia, and the amount of in controversy exceeds $75,000. So it's true. She sued her, and it wasn't even for $100K. Upon information and belief, Kebe is subject to personal jurisdiction in the state of Georgia, as she resides in and or is domiciled in Georgia. In addition, upon information and belief, Kebe owns, uses, and possesses real property within the state of Georgia, regularly transacts business, and as described below within the state of Georgia, and committed a torturous act within the state of Georgia, including the torts of invasion of privacy, false light. 7. Upon information and belief, Jones is subject to personal jurisdiction in the state of Georgia, as she resides in and or is domiciled in Georgia. In addition, upon information and belief, Jones owns, uses, and possesses real property within the state of Georgia, regularly transacts business, as described below within the state of Georgia, and committed a torturous act within the state of Georgia, including the torts of invasion of privacy, false light. 8. Venue is proper in the district pursuant to 28 U.S.C. Code 1391, because Kebe and Jones are residents of this district, and because, upon information and belief, the conduct complained of occurred in this district. Factual background. Now, I want everybody to listen to this. Number 9. Plaintiff is a Grammy Award-winning musical artist, songwriter, and television personality, professionally known as Cardi B. 10. Since the release of her full-length debut mixtape in 2015, Plaintiff's musical works have reached peak positions on charts in the United States and around the world. As a result of the popularity of her music, Plaintiff has millions of fans in the United States and around the world who follow her work and her social media profiles. 11. Plaintiff is a young mother. Plaintiff is also a mother of a young baby girl. 12. In addition to her artistic endeavors, Plaintiff is well known for her volunteer work and philanthropic endeavors, which includes helping families affected by gang violence and performing volunteer work and handing out coats to underprivileged persons. 13. Upon information and belief, Jones is a natural person who claims to have known Plaintiff before her musical career. 14. Upon information and belief, Jones currently conducts business in the nature of promoting anti-Asian products. 15. Upon information and belief, however, Jones's real aspiration is to have a career in the entertainment industry as an actress. Upon information and belief, in pursuance to this goal, Jones promotes herself and her entertainment endeavors through social media, where she has about 10,000 followers. 16. Upon information and belief, Jones regularly posts information regarding her endeavors in the entertainment industry in and around Atlanta. 17. Upon information and belief, Kebe Products hosts and publishes videos on YouTube entitled Unwind with Tasha K. 18. Upon information and belief, while Kebe calls her site a celebrity gossip site, the real purpose of Unwind with Tasha K is to provide a platform for Kebe to publish and spread malicious rumors, slanderous assertions, and false information about celebrities, including Plaintiff, for her personal financial gain. Upon information and belief, Kebe does this to draw various celebrities social media followers to her site, including plaintiff's social media followers, so she can increase what she charges for advertising to third parties that advertise with her. Upon information and belief, over the past year, Kebe targeted plaintiff and began making degrading statements regarding plaintiff. 21. Upon information and belief, while plaintiff was pregnant on or around April 13, 2018, Kebe published a video where Kebe stated that as a result of plaintiff's actions, plaintiff's then unborn child may have intellectual disabilities. I remember that. 22. Upon information and belief, in the past few months, Kebe has taken her vitriol one step further by making blatantly defamatory statements regarding plaintiff. 23. Upon information and belief, Kebe has become obsessed with slandering plaintiff. She really did. In the last 14 months, Kebe has put out at least 23 videos regarding plaintiff. 24. Upon information and belief, as set forth, Kebe's videos about plaintiff attract substantially more viewers than most of her other videos, which is part of the reason she has repeatedly targeted plaintiff. 25. Upon information and belief, to this end, Kebe has published in the past few months several videos with more false and defamatory statements about plaintiff, who has become the target of Kebe's malicious campaign to damage and destroy plaintiff's reputation among her fans and the consuming public. 26. Upon information and belief, on or around September 2nd, 2018, Kebe published a video entitled Cardi B Disrespectful Comedy Skit Mocking Martin Luther King's Extramarital Affairs. The 9/2 video. 27. The 9/2 video contains at least one false and defamatory statement about plaintiff. 28. The 9/2 video contains a false, malicious, and defamatory statement that plaintiff prostituted for a living. 9/2 video at the 50-50 mark. Upon 29. Upon information and belief, Kebe published a 9/2 video to tens of thousands of individuals without privilege or justification. 30. Upon information and belief, around the same time, on or around September 13, 2018, Jones published a video of herself to her Instagram followers, making false, malicious, and defamatory statements regarding plaintiff through Instagram Live, which allows users to film live videos that can be watched either simultaneously by their followers or within 24 hours of their posting. In parentheses, the Jones video. 31. The Jones video contains multiple false and defamatory statements about the plaintiff. 32. In the Jones video, Jones made the false and malicious defamatory statement that plaintiff got herpes. Jones's video at the 9:38 mark. 33. In the Jones video, Jones also made the false, malicious, and defamatory statement that plaintiff took Molly and cocaine. Specifically, she stated the more Molly pills she would be taking, the more cocaine she would be taking. Jones's video at 14:24 mark. 34. In the Jones video, Jones also falsely stated that plaintiff was engaging in prostitution. Specifically, she stated, referring to plaintiff, I guess they were supposed to have sex, exchange sex for money. Jones video at 15:50 mark. Shortly after Jones released the Jones video, on or around September 13, 2018, Jones also published written comments on her Instagram account to third parties that plaintiff is, in quotations, just a Grammy-nominated prostitute running around spreading her herpes. In parentheses, the Instagram comment. 36. Upon information and belief, continuing her campaign of slander and to capitalize on Jones' slander, on or around September 19, 2018, Kebe recorded and later published a video of herself interviewing Jones. regarding the Jones video on YouTube entitled Exclusive. Cardi B's ex-friend alleges Cardi B kept a huge box filled with monostat and reveals more. In parentheses, the 919 video. 37. Upon information and belief, Kebe knew that publishing a video regarding plaintiff would draw substantially more viewers to her content than she typically garners. And I want to pause and say that is true because that is her highest viewed video with over 4 million views. And that pushed her sub count from close to 300K to the 500K mark. So she had at that time, about 290 or 270K subs. And it got pushed and within a month to about 520K subs. So yeah, she had ended up in like the 500,000 sub rank. 38. Upon information and belief, the 919 video to date has garnered over 3 million views. By way of comparison, upon information and belief, the last full-length video Kebe published prior to the 919 video only garnered approximately 223,000 views. That is true. 339. Upon information and belief, only 9 of her approximately 236 videos published prior to the 919 video garnered over 1 million views. 40. The 919 video contains multiple false and defamatory statements about the plaintiff. 41. The 919 video contains a false, malicious, and defamatory statement that plaintiff was a prostitute. At the 42nd mark, in quotations, Kebe says, "You said that Cardi B prostituted," in quotations. In quotations, Jones replies, "Yes." 42. The 919 video contains a false, malicious, and defamatory statement that plaintiff used cocaine and Molly. 42nd mark, Kebe, was she a drug user? In quotations. Ms. Jones, in quotations, says yes. Kebe reads, says cocaine and Molly to be specific. And Jones replies, yes. 43. The 919 video contains the false, malicious, and defamatory statement that plaintiff has herpes. 48 seconds, in quotations, Kebe, she has herpes. Question. Jones replies, yes. 44. The 919 video contains a false, malicious, and defamatory statement that plaintiff also had herpes outbreaks on her mouth in the past. 17 minutes, 25 seconds. Kebe says, so you were living with her at the time and she had herpes outbreaks on her mouth. In parentheses, Jones reads yes. 45. Upon information and belief, Kebe published the 919 video to millions of individuals without privilege or justification. 46. None of the aforementioned statements about plaintiff are true. Plaintiff was never a prostitute or user of Molly and cocaine. Plaintiff has never and does not now have herpes, nor has she had herpes outbreaks on her mouth. 47. Upon information and belief, defendants knew or should have known that the aforementioned statements were false. 48. Upon information and belief, defendants were subjectively aware of the probable falsity of the aforementioned statements at the time they published them. 49. Upon information and belief, by way of example, on a second YouTube channel operated by Kebe posted a video that acknowledges that she was aware prior to her publishing the 919 video that the defamatory statements made by Jones may not have been true. That's very important. 50. Upon information and belief, Kebe further acknowledges that she published the 9/19 video a day earlier than she had planned to because information undermining Jones' credibility was about to be published, and Kebe wanted the 9/19 video to have opportunity to trend, i.e. gain viewership before people saw the information and would debunk Jones' statement. And I want to pause on the reading of the documents for a second. What she is talking about is in reference to Lovely T telling Tasha K that she doesn't believe that Jones was telling the truth. She thought she was a liar. So this is the whole falling out that they had in reference to that. And Jones has said that her and Lovely T agreed that she would put out her video first, and then Lovely T will put out her video second afterwards. So that's one, which that's in reference to number 50. 51. Upon information and belief, the aforementioned defamatory statements were made and published by defendants with actual malice, with knowledge that the statements were false or with reckless disregard for the fact that they were false. On or about September 19, 2018, shortly after Kebe published the 9/19 video, plaintiff, through her counsel, sent a cease and desist letter to Kebe that demanded immediate removal of the defamatory video. 53. Upon information and belief, 2 days after receiving the letter, which she posted on social media, rather than to take the video down or issuing a retraction and or repudiation, Kebe published a second video that falsely proclaimed the statements made in the 9/19 video were true. 54. Upon information and belief, on or around September 21st, 2018, Kebe published a second video entitled Actual Proof. Cardi B knew her ex-roommate, Drake, Funky Dineva versus Tamar, Beyonce, Black Magic, where she unequivocally stated that everything said in the 9/19 video was true, in reference to the 9/21 video. The 9/21 video also continued Kebe's campaign of defamation. 56. Upon information and belief, in the 9/21 video, Kebe claims that everything that Jones said was accurate. 9/21 video at the 2-minute 11-second mark. That Kebe was, in quotations, the source. 9/21 video at 4 minutes 38 seconds. Upon information and belief, Kebe even went so far as to falsely suggest that she was in possession of undisclosed facts that would support the prior statements when she further claimed that Jones has shown me some stuff. I said, okay, legit. So I'm going to go ahead and tell your story. 9/21 video at 8-minute 12-second mark. 58. Since then, Kebe has continued her campaign of defamation and harassment. Even as recently as January 25th, 2019, Kebe tweeted that the plaintiff had herpes. Specifically tweeting at plaintiff, Kebe wrote that plaintiff had a confirmed irritated PUSSY, which she followed with herpes B. Hashtag herpes B. The 125 tweet. 59. Upon information and belief, the 125 tweet was published to Kebe's over 6,000 followers. Now, okay, so that's Twitter. She has 6,000 followers on Twitter. 60. Upon information and belief, shortly after it was posted, knowing it was not true, Kebe deleted the post. However, as set forth below, she has failed and refused to repudiate and take down the other instances of defamatory statements in the above described videos. 61. The aforementioned defamatory statements published by Jones have caused plaintiff to suffer embarrassment, humiliation, mental anguish, and emotional distress. The aforementioned defamatory statements distributed, published, and repeated by Kebe have caused plaintiff to suffer embarrassment, humiliation, mental anguish, and emotional distress. 63. The aforementioned defamatory statements published by Jones have also caused damage to plaintiff's reputation and character with her profession and industry, including but not limited to among her fans with prospective business relations. 64. The aforementioned defamatory statements distributed, published, and repeated by Kebe have also caused damage to plaintiff's reputation and character within her profession and industry, including but not limited to among her fans and with prospective business relations. 65. Pursuant to OCGA Code 51-5-12 and OCGA Section 51-511A, on February 28, 2019, plaintiffs sent demands for retraction and refutation to Kebe and Jones, demanding a retraction and repudiation of the aforementioned defamatory statements. 66. Despite due written demand and the passing of at least 7 days, Kebe and Jones have, as of the date of filing of this complaint, failed and refused, excuse me, I had to sneeze, to refuse and retract and or repudiate the aforementioned defamatory statements. As 67, as of this day, neither Kebe nor Jones have issued any sort of retraction or repudiation of the defamatory statements. So before all this happened, they had time to really retract everything, either apologize or just say, we was wrong, misquoted, and so forth. Okay, now we go into the counts. Count 1, slander per se against defendants. 68. Plaintiff repeats and re-alleges by reference the allegations in paragraphs 1 through 67 as it is fully set forth herein. 69. Upon information and belief, Kebe published a 9/2 video on or around September 2nd, 2018. 70. Upon information and belief, Jones published the Jones video in or around September 13, 2018. 71. Upon information and belief, Kebe published a 2019 video on or around September 19, 2018. Point 72. Upon information and belief, as set forth above, the 9/2 video and 9/19 videos published by Kebe contain multiple false and defamatory statements about plaintiff, including that the plaintiff was a prostitute and a user of cocaine and Molly, that plaintiff had and still has herpes, and that the plaintiff has had herpes outbreaks on her mouth. 73. Upon information and belief, as set forth above, the Jones video published by Jones contains multiple false and defamatory statements about plaintiff, including that plaintiff was a prostitute and a user of cocaine and Molly, and that plaintiff has herpes. 74. None of the aforementioned statements about plaintiff in the Jones video, 9/2 video, or the 9/19 video are true. 75. Upon information and belief, defendants knew these statements to be false at the time they published them, or the defendants were subjectively aware of the probable falsity of the aforementioned statements at the time they were respectively published them. 76. Upon information and belief, by way of example, on a second YouTube channel operated by Kebe posted a video that acknowledges she was aware, prior to the publishing of the 9/19 video, that the defamatory statements made by Jones may not have been true. 77. Upon information and belief, Kebe further acknowledged that she published the 9/19 video a day earlier that she had planned to, because information undermining Jones' credibility was about to be published, and Kebe wanted the 9/19 video to have had an opportunity to trend, i.e. gain viewership, before people saw the information that would debunk Jones' statements. So in other words, she wanted to also get the views because she wanted to crack not just 1 million, but she wanted to go past the 1 million mark and reach the 2 million mark with that video, which she did. It went up to like 2.5, and then it went to about 3 million within a couple of months later. 78. Nevertheless, upon information and belief, after receiving a cease and desist letter demanding she take down the defamatory statements about plaintiff in the 919 video, Kebe published another video on September 21st, 2018 that referred to the 919 video and the Jones video and falsely stated that everything that we said, that everything that, in quotation, Jones said was accurate. 921 video at the 2-minute 11-second mark. That Kebe was the source. 921 video at 4:38 seconds. 79. Upon information and belief, neither Jones nor Kebe made reasonable attempts to verify the false and defamatory statements that were made about plaintiff before the 922 video, Jones video, 919 video, or 921 video. Collectively, the defamatory videos were published. 80. Upon information and belief, Jones knew that the statements made in the Jones video and the 919 video were false, or Jones acted with reckless disregard of whether they were true or not. 81. Upon information and belief, Kebe knew the statements made in the defamatory video were false, or Kebe acted with reckless disregard of whether they were true or not. 82. Upon information and belief, defendants published these false statements via YouTube and Instagram and identified plaintiff by her professional name, her occupation, her showed photos of plaintiff during the videos so that individuals who watched them would know the statements made in the videos were about the plaintiff. 83. Upon information and belief, defendants' false stories were generated with communicated with actual malice towards total disregard for the truth and in complete absence of any special privilege. 84. Upon information and belief, Kebe has had no basis for claiming that the statements in the 921 video were true. 85. Upon information and belief, the 922 video has been viewed by tens of thousands of people. 86. Upon information and belief, the Jones video has been viewed by thousands of people. Upon 87. Upon information and belief, the 919 and 921 videos have been viewed by hundreds of thousands of people. 88. Upon information and belief, the 922, 919, 921 videos are still available to be viewed by the public. 89. Upon information and belief, these actions constitute actionable slander per se under OCGA Section 51-5-4 in parentheses A in parentheses 2. 90. Upon information and belief, defendants' false and defamatory statements made and published in the defamatory videos were disparaging and have produced damage to plaintiff's name, character, and reputation. 91. The aforementioned defamatory statements made and published by Jones have caused plaintiffs to suffer embarrassment, humiliation, mental anguish, and emotional distress. 92. The aforementioned defamatory statements made and published and distributed by Kebe have caused plaintiffs to suffer embarrassment, humiliation, mental anguish, and emotional distress. 93. The aforementioned defamatory statements made and published by Jones have also caused damage to plaintiff's reputation and character within her profession and industry, including but not limited to among her fans and with prospective business relations. 94. The aforementioned defamatory statements made, published, and distributed by Kebe have also caused damage to plaintiff's reputation and character within her profession and industry, including but not limited to among her fans and with prospective business relations. Upon information and belief, defendants' actions constitute slander, and as such, plaintiff is entitled to special damages in amount to be proven at trial. 96. Upon information and belief, the actions or omissions of defendants set forth in this complaint demonstrate malice egregious defamation and insults. 97. Upon information and belief, such actions or omissions by defendants were undertaken with reckless disregard or the falsity of the speech and its effects on plaintiff. 98. Plaintiff is entitled to general and specific damages for the following: harm, emotional distress, and impairment to her name, character, and reputation. 99. Additionally, plaintiff requests an award of punitive damages and attorney's fees beyond and in excess of those damages necessary to compensate plaintiff for injuries resulting from defendant's conduct. 100. Additionally, as a direct and proximate result of the foregoing, plaintiff is entitled to an order permanently enjoining defendants and all their respective agents, officers, employees, representatives, successors, assigns, attorneys, and all other persons acting for, with, by, through, or under authority for Kebe and or Jones, or in concert or participation with Kebe and or Jones, and each of them from making, disseminating, broadcast, or publishing any statements that plaintiff has or had herpes, that plaintiff uses or has used cocaine and or Molly, and or that plaintiff was or is a prostitute, as well as an order requiring Kebe and Jones to retract, remove, and repudiate in full all defamatory and disparaging statements made regarding plaintiff. 12 more to go. Count 2. Slander against defamation. Slander against defendants. Plaintiff repeats and realleges by reference allegation in paragraphs 1 through 100 as if fully set forth herein. Upon information and belief, defendants' above actions constitute actionable slander under OCGA section 51-5-4 in parentheses A, parentheses 4. Upon information and belief, defendants' false and defamatory statements made during the above referenced videos were disparaging and have produced damage to plaintiff and to plaintiff's name, character, and reputation. Upon information and belief, defendants were subjectively aware of the probable falsity of the statements made during the above referenced videos at the time she published them. Upon information and belief, defendants' actions constitute slander, and as such, plaintiff is entitled to special damages and the amount to be proven at trial. Upon information and belief, the actions or omissions of defendants set forth in this complaint demonstrate malice, egregious defamation, and insult. Upon information and belief, such actions and omissions by defendants were undertaken with reckless disregard for the falsity of the speech and its effects on plaintiff. Plaintiff is entitled to general and special damages for the following: harm, emotional distress, and impairment to her name, character, and reputation. The aforementioned defamatory statements made and published by Jones have caused plaintiff to suffer embarrassment, humiliation, mental anguish, and emotional distress. The aforementioned defamatory statements made, published, and distributed by Kebe have caused plaintiffs to suffer embarrassment, humiliation, mental anguish, and emotional distress. The aforementioned defamatory statements made and published by Jones have also caused damage to plaintiff's reputation and character within her profession and industry, including but not limited to among her fans and with prospective business relations. The aforementioned defamatory statements made, published, and distributed by Kebe have also caused damage to plaintiff's reputation and character within her profession and industry, including but not limited to among her fans and with prospective business relations. Additionally, plaintiff requests an award of punitive damages and attorney's fees beyond and in excess of those damages necessary to compensate plaintiffs for injuries resulting from defendant's conduct. Additionally, as a direct and proximate result of the foregoing, plaintiff is entitled to an order permanently enjoining defendants and all their respective agents, officers, employees, representatives, successors, assigns, attorneys, and all other persons acting for, with, by, through, or under authority from Kebe and or Jones, or in concert or participation with Kebe and or Jones, and each of them from making, disseminating, broadcasting, or publishing any statements that plaintiff has or had herpes, that plaintiff uses or has used cocaine and or Molly, and or that plaintiff was or is a prostitute, as well as an order requiring Kebe and Jones to retract, remove, and repudiate in full all defamatory and disparaging statements made regarding plaintiff. Count 3. Libel per se against defendants. Plaintiff repeats and re-alleges by reference the allegations in paragraphs 1 through 114 as if fully set forth herein. Upon information and belief, Jones published the Instagram comment on or around September 13, 2018. Upon information and belief, Jones published these false statements via Instagram. Upon information and belief, Kebe published the 125 tweet on or around January 25, 2019. Upon information and belief, Kebe published this false statement via Twitter. As set forth above, the statements made in the Instagram comment and the 125 tweet contain false, defamatory, and libelous statements regarding plaintiff, including plaintiff having been a prostitute and having herpes. None of the aforementioned statements about plaintiff in the Instagram comment or the 125 tweet are true. Upon information and belief, defendants knew these statements to be false at the time they were respectively published. As false at the time they respectively published them or acted with reckless disregard of whether they were true or not. Upon information and belief, defendants were subjectively aware of the probable falsity of the aforementioned statements at the time they each published them. Upon information and belief, defendants' false stories were generated and communicated with actual malice, total disregard for the truth, and in the complete absence of any special privilege. Upon information and belief, defendants had no basis for claiming the aforementioned statements were true. Upon information and belief, the Instagram post containing the Instagram comment has been viewed by thousands of people. Upon information and belief, the 125 tweet was published to Kebe's over 6,000 Twitter followers. Upon information and belief, these actions constitute actionable libel per se under OCGA section 51-5-1. Upon information and belief, defendants' false and defamatory statements made in the Instagram comment and 125 tweet were disparaging and have produced damage to plaintiff and to plaintiff's name, character, and reputation. The aforementioned defamatory statements made and published by defendants have caused plaintiff to suffer embarrassment, humiliation, mental anguish, and emotional distress. The aforementioned defamatory statements published by defendants have also caused damage to plaintiff's reputation and character within her profession and industry, including but not limited to among her fans and with prospective business relations. Upon information and belief, defendants' actions constitute libel, and as such, plaintiff is entitled to special damages in an amount to be proven at trial. Upon information and belief, the actions or omissions of defendants set forth in this complaint demonstrate malice, egregious defamation, and insult. Upon information and belief, such actions or omissions by defendants were undertaken with reckless disregard of the falsity of the speech and its effects on plaintiff. Plaintiff is entitled to general and special damages for the following: harm, emotional distress, and impairment to her name, character, and reputation. Additionally, plaintiff requests an award of punitive damages and attorney fees beyond and in excess of those damages necessary to compensate plaintiff for injuries resulting in defendant's conduct. Additionally, as a direct and proximate result of the foregoing, plaintiff is entitled to an order permanently enjoining defendants and all their respective agents, officers, employees, representatives, successors, assigns, attorneys, and all other persons acting for, by, through, or under authority from Kebe and / or Jones, or in concert or participation with Kebe and or Jones, from making, disseminating, broadcasting, or publishing any statements that plaintiff has or had herpes, and or that plaintiff was or is a prostitute, as well as an order requiring Kebe and Jones to retract, remove, and repudiate and for all defamatory and disparaging statements made regarding plaintiff. Count 4, invasion of privacy, false light against defendants. Plaintiff repeats and realleges by reference the allegations in paragraphs 1 through 137 as a fully set forth herein. Upon information and belief, by publishing the false allegations in the manner described above, defendants portrayed plaintiff in a false light intended to cause plaintiff injury. Upon information and belief, Jones and Kebe knew these statements to be false. Upon information and belief, Jones and Kebe made no attempt to verify the veracity of any statements made regarding plaintiff. Upon information and belief, Jones knew the statements made in the Jones video, 919 video, and the Instagram comments were false. Upon information and belief, Kebe knew the statements made in the 9-2 video, 919 video, 921 video, and the 125 tweet were false. Upon information and belief, Jones was subjectively aware of probable falsity of the statements made in Jones' video, 919 video, and the Instagram comment were false at the time she published them. Upon information and belief, Kebe was subjectively aware of probable falsity of the statements made in the 9-2 video, 919 video, 921 video, and the 125 tweet at the time she published them. Upon information and belief, defendants' false statements were generated and communicated with actual malice, total disregard for the truth, and in the complete absence of any special privilege. Upon information and belief, as set forth above, defendants have intentionally intruded upon the solitude and or seclusion of plaintiff in our private affairs and or concerns, and in this intrusion, which falsely portrays plaintiff having a loathsome, contagious, and infectious disease, is highly offensive to a reasonable person. Facts. Upon information and belief, defendants have also intentionally intruded upon the solitude and or seclusion of plaintiff in her private affairs and or concerns, and this further intrusion, which falsely portrays plaintiff as being a former prostitute and a use of cocaine and / or Molly, and is highly offensive to a reasonable person. Upon information and belief, defendants knew or should have known the statements alleged herein would create a false impression about plaintiff and acted in reckless disregard of the truth. As a direct and proximate result of defendant's conduct, plaintiff has suffered damages in the amount to be proven at trial. Upon information belief, defendants did not engage in any of the aforementioned conduct out of any sincere or proper motive or in any manner, governed by reasonable and ministerial conduct according to any job duty, but did so knowingly, willfully, and oppressively with full knowledge of the adverse effects that their action would have on plaintiff and with willful and deliberate disregard for the consequences. Accordingly, plaintiff is entitled to recover punitive damages from defendants in an amount to be determined at trial. Upon information and belief, the actions or omissions of defendants set forth in this complaint demonstrate malice, egregious defamation, and insults. Such actions or omissions by defendants were undertaken with reckless disregard of the falsity of the speech and its effects on plaintiff. Plaintiff is entitled to general and special damages for the following harm: emotional distress and impairments to her name, character, and reputation. Additionally, plaintiff requests an award of punitive damages and attorney's fees beyond in excess of those damages to compensate plaintiff for injuries resulting from defendant's conduct. Additionally, as a direct and proximate result of the foregoing, plaintiff is entitled to an order permanently enjoining defendants and all their respective agents, officers, employees, representatives, successors, assigned attorneys, and all other persons acting for, with, by, through, or under authority for Kebe and or Jones, or in concert or participation with Kebe and or Jones, and each of them, from making, disseminating, broadcasting, or publishing any statements that plaintiff has or had herpes, that plaintiff uses or has used cocaine and or Molly, and or that plaintiff was or is a prostitute, as well as an order requiring Kebe and Jones remove in full all defamatory and disparaging statements made regarding plaintiff. Prayer for relief. Wherefore, plaintiff respectfully requests the court to enter judgment in her favor and against defendants, each of them jointly and severally, as follows. A. Awarding plaintiff damages and amounts pertaining to each to be determined at trial, but no less than $75,000, including general, special, consequential, actual, statutory, or punitive damages. B. Awarding and accounting to plaintiff for the gains and profits of defendants arising from the unlawful conduct. C. Permanently enjoining defendants and their prospective partners, agents, representatives, successors, assigns, and employees, and any and all persons in active convert or participation with defendants and each of their executors, administrative successors, licensees, assigned subsidiaries, parents, affiliates, divisions, co-ventures, partners, officers, directors, employees, agents, shareholders, managers, representatives, consultants, and any and all other persons, corporations, or other entities acting under the supervision, direction, control, or on behalf of any other foregoing, and each of them from making, disseminating, broadcasting, or publishing any statements that plaintiff has or had herpes, that plaintiff uses or has used cocaine and or Molly, and or that plaintiff was or is a prostitute. D. Issuing an order requiring Kebe to retract, remove, and repudiate in full all defamatory and disparaging statements made regarding plaintiff. E. Issuing an order requiring Jones to retract, remove, and repudiate in full all defamatory and disparaging statements made regarding plaintiff. F. Awarding plaintiff's attorney fees and costs. G. Prejudgment and post-judgment interest. And H. Granting plaintiff such other and further relief as the court deems just and proper. Jury trial demanded. Plaintiff hereby demands a trial by jury on all claims for relief and issues triable by jury. I'm not laughing at this. I'm going to tell you what I'm laughing at. Dated March 21st, 2019. Respectfully submitted. Lisa F. Moore, Gary P. Elderman. Pro hoc vice application to be filed. Sarah M. Mass. Pro hoc vice application to be filed. Edelman Mass. PC. 1173A 2nd Avenue, Suite 153, New York, New York, 165. And Lisa F. Moore, W. Andrew Peckquignogg, Moore Peckquignogg, LLC, 887 West Marietta Street, Suite M102. Attorneys for plaintiff. Now, I want to talk about Mr. Peckquignogg. He's the one that's representing her. The one that you see in the trial currently, that's the one whose name is mentioned. So she got her lawyers from New York to file because that's her legal representation. But also, she got the lawyers down in Georgia, because remember her husband is from Georgia, Offset. So she got all those people to basically have her back to represent her. Now, Tasha K got Olga. Olga gave her misinformation, encouraged her to file a $3 million countersuit, and she lost. That's why I started laughing when it came to the all jury claims relief and issue, because that image came up. Now, I'm going to talk about this for like 20 minutes, and I'm going to make some comments because I think this is very much important. If you notice, the infamous Star Marie, she's not being mentioned. Hold on, I'll be right back. Give me about 1.5 minutes. I gotta do something. Thank you for being patient. I had to take care of some business, if you know what I mean. But anyway, Thank you for being patient and listening to me reading all those documents. That was 29 pages of legal documents, with the 30 being the representatives from Cardi B, Miss Almánzar. I want to say this. Cardi B, in reading these documents, Cardi B is not a vindictive person. She's a person for justice, but she's not vindictive. She gave Tasha K and Star Marie so many chances, particularly Tasha K, because Star Marie had her Instagram page. She had like a couple of 100 followers and so forth, but Star Marie didn't have the power. She just brought something powerfully damaging to an internet personality. This young lady allowed to give them ample amount of time. Just retract it. Take it down. Then I'll move on with my life. Admit that what you did was wrong and that you lied. You committed libel and slander. They wouldn't do it because Tasha K not only wanted to be big, but she needed to be big. Star Marie, in March, as soon as those papers were filed, she was in New York talking, and you can see this on Michelle A.T. Alien Brown's YouTube channel, and I'm going to post that video, where she's talking about she hasn't served me anything. I haven't had the papers. Well, of course you didn't get the papers if you're in New York and they mail it to your address that's in Georgia. Of course you didn't get it. All right? But if you notice one thing about Star Marie, the minute that the papers was filed and it went public, you never heard Star Marie again. I just looked up the YouTube channel. I am Love Star Marie 13, okay? That channel, that video, that Instagram page is still up. But she doesn't have herself on it. She deleted all the posts. She just has the amount of people that are following her and how many she follows. All the content is gone. Now, I mentioned Sean Davy Way earlier and how he posted a live. He did a live that he still has posted up about how come Star Marie was removed from the lawsuit. Okay? He said something that I believe is factual. He said that he believes that Star Marie, when she got served, she made a deal with Cardi B's legal team to where it's like, listen, I'll jump on your side. I won't make any more videos about Cardi B. I'll take all the posts down. And I won't retract publicly, but I'll retract privately. And that way, I'll just, say, listen, I was invited to come on this woman's show. Yes, I did it. I did it because of malicious intent. I'm trying to break into business. I've been there for years. I never got my turn. She didn't grind as long as I did, but she came up. And Tasha K saw my videos as well as other YouTube bloggers, because let's keep it real. Everybody wanted that Star Marie interview. But Tasha K probably paid her, whereas the others weren't going to pay her money. So it was like, I'm getting money out of it. Of course, I'm going to come there. And then my name is going to get out there, and then I'm going to get exposure too. Let's not get it twisted. She wasn't just doing it just to, hurt Cardi. She was trying to come up as well. And for like the rest of 18, Homegirl's name was trending on the internet. Okay? But once those papers was filed, you haven't seen her since. That's why today on my main channel, I posted whatever happened to Star Marie. Please listen to it, because I did bring up a lot of valid points. I also posted up the thing about how this whole situation that Tasha K did, even though Star Marie did it too, but Star Marie didn't have a YouTube channel. Her thing was on Instagram. But on YouTube, I hold Tasha K accountable, because Tasha K is going to make it harder for all content creators. Even the ones that are doing the thing right, because they're going to always scrutinize everything that we post in terms of advertisement, in terms of paying us, in terms of even allowing the content to still be up if we want the channel to continue to be monetized. Okay? This thing is huge. But Star Marie probably was like, nah, they got my Georgia address. Not my New York address. They got my Georgia address. And it's posted. These documents are legal. Now, I didn't read the bills and number. I read the drive and the lane. Same thing with Tasha. Now, they don't have Cardi B's address, but hey, she's the victim. Now, you haven't heard from Star Marie. She hasn't been in the courtroom. But I believe she made a deal with the plaintiffs, for Cardi B's team. And I believe that Sean Davy Way is accurate about that. And it's to make herself, not known. Now, where did she disappear to? Is she still in America? Is she still, did she go to leave the country? I looked up her LinkedIn page. And what I found is that she actually is studying film at this institution in Georgia. Not Georgia, in Chicago. And that she graduated from there in 2021. Because remember, she was talking about how she wanted to make it in the acting world. I don't know if it's true, if she got the degree or what. But she was posting her IMDb channel. It could be a throw off. Who knows? Or maybe it's legit. But she supposedly have her bachelor's in theater and film video production. So that's all we know. And the university is not like a university. It's like a college for theater, film, and mass communication. All right. So moving along with Star Marie, I want to focus on Tasha Transrena Kebe. You blew your chance of being famous working in the media by pulling this stunt. You played yourself. You allowed anger, being sunned by Cardi B with not giving you the interview, to where you not only talked about, you brought a woman there talking about an STD, but you, before all this going on, you talked about Cardi B's child having a mental impairment. Okay? So before the whole Star Marie thing, you was doing stuff. And even then, they asked you, just take it down, retract it, apologize. But you saw the money, the clout, the viewership, and you saw that you could use Cardi B in terms of slandering her, dirtying her name, destroying her credibility, so you could come up and it can open your door to the industry. Sorry, sweetheart, it backfired on you because nobody's going to ever want to touch you. Okay? Also, the $75K, that's the lowest amount that Cardi B and her lawyers is asking. That's not even including legal fees. So the slander, the libel, that can be $75K. But still, she's going to have to pay the legal fees. I believe it's going to all add up to millions. That's just my thing. I said $3 million. I may lower it to I'll lower it to $2 million, 1.5, but that's just my belief. But that's the least amount. A lot of people misquoted it and say that she's suing her for $75K. No, she's suing her for a minimum of $75K, excluding court fees. That's serious. That's why Tasha K probably did that countersuit with the $3 million. Now, with the Tasha K countersuit, that had to do with people, she said, from Cardi's camp that threatened her, gang affiliations, people was coming after Tasha K, but she was lying on them, bringing up stuff that had nothing to do with even a slander. You brought in Remy Rojo, you brought in Star Brim, you brought in all these other people. Then you was linking her to Tekashi 6ix9ine. Then you was linking her to a whole bunch of other things, and certain things that you could have talked about that was legit, you did not talk about because you wanted to just simply dirty Cardi B's name. Well, now guess what? It's landed you in civil court. Mind you, they reported that you on Friday, Tasha Kebe, you perjured yourself. Now, this is a federal case. This is a federal lawsuit. This is not a state lawsuit. That's why it reads in the state of Georgia, Atlanta division. Okay? The city is important because it is a lawsuit, but they had to let it be known this is federal. Because when it comes to federal suits, you have different divisions. Like, for instance, in New York, where I'm from, if it's a federal suit, the jurisdiction will definitely mention the state of New York, the Southern District, okay? The Southern District. Southern District of New York is New York City in terms of dealing with Manhattan and dealing with the Bronx. Then you have a separate one dealing with Brooklyn, dealing with Queens, and so forth, because those are different areas. Now, if this was a state lawsuit, it would have mentioned the county because states deal with counties. But when it comes to the federal, it deals with divisions. Now, I want to say something. I have a degree in paralegal studies. I talk about that on my other channel. And I haven't worked at it in a long time. It's been, let me see. We're talking about 7 years ago that I finished. And I have been dealing with quite a few personal things. So there were things that I misquoted. So I want to make a disclaimer that I said codes instead of sections, but it's sections. So I want to state that. So that was, my fault when I said that. I was supposed to say section with the SSS. Now, anyway, getting back to the whole thing. Federal lawsuits are no joke. Perjury is no joke. You cannot lie on the stand. Do you know this woman, after this, can face up to like 5 years for just perjuring in a federal case? Cardi B will have gotten her money, moved on, and she will still be in the court for lying. She'll then lose her privilege to testify in a court of law in the future. She threw her husband under the bus. Who the F is the president of Kebe Studios? Kebe Studios is going to be dissolved. Let's keep that a bean. Shout out to Jaguar Wright for that. Okay. Also, Bobby Lights is planning to sue her. Okay. Jaguar Wright could sue her now. Because once her credibility is shot, because Cardi is going to win. Let's keep it real. How much money she'll get, we don't know. It could just be just a $75K. But this woman for 3 years harassed her, talked about her, and admitted on video, I did it for the money. I did it for the money. I did it for the clout and the money. I'm not going to pay her nothing. She says this. You can look it up. But see, here's the catch-22. And I've been saying this for the longest. Yes, Tasha K does things crazy. Yes, Tasha K is off her rockers. Yes, Tasha K is disrespectful. She has an evil disposition. She is unethical to the highest degree. She's all those things, and she is bad for YouTube. But there's one thing that I will say about Tasha K. I don't believe Tasha K did this thing on her own. I will stand by it and say there were people in the background behind her that she probably believed would have her protected, so that if any of this was to go down like this, they would probably be like, okay, you're going to use the money, whatever, but it's still going to open doors for you. It's not going to dirty your name. It's not going to dirty your brand. We're going to basically, make sure that you're protected. Oh, you're not going to go to jail. But the woman was so sloppy in herself that now these people are pulling away. Notice how she hasn't been uploading like that, because her team is falling apart. Because they don't want to be caught in this, because they're realizing that once Cardi B medical records came back and said she didn't have herpes, now we working with a woman that's been a complete libelous and slander and defamer the whole time. I need to stay in this industry. I'm trying to move up too in the background. I got to work. I got to eat. I can't let this ruin me. I got family to feed. See, now everybody want to pull away. But see, when the getting was good 3 years ago, y'all didn't tell this woman to pause. All y'all from KB Productions, Kebe Studios, LLC, Domestic Limited Liability Corporation. Y'all didn't say anything. Y'all let it go because you probably got gassed and juiced in the head with the people who were the i.e. investors of the brand. Oh yeah, we got y'all. Y'all good. Y'all good. We gonna take care of it. You know, whatever. See, here's the thing. The general public are infamous for filing lawsuits against the rich and famous. But the rich and famous never files lawsuits against the people who are the regular, everyday citizen. Okay? Even though Tasha K is a YouTube personality, she was still a regular citizen. She was not famous. She was just a vlogger and a blogger. Star Marie was just a regular citizen who dabbled in the industry, doing exotic dancing, doing videos, you know, trying to break in as an actress, but she was not a public figure. Okay? This is a historic lawsuit. They didn't believe that Cardi B would sue. Because who would sue? Who, as a multimillionaire, who had an album go double platinum, who made history as having their very first song, debut single, go #1 to the charts? Okay? Who would think that? Who would think somebody like her, who blew up miraculously, has a fairy tale story when it comes to the industry, going from reality TV, Love and Hip Hop, the biggest breakout star of Love and Hip Hop, which is what the show was supposed to be. She did that. She brought the credibility to it in terms of, yeah, I'm going from hip hop, Love and Hip Hop, reality TV, to making $1 million single, 2-3 million selling hit single, to having a double platinum album. I'm on SNL performing. I'm selling out stadiums, and I win a Grammy. Who would think she would sue a blogger? Nobody. Because you know why? Because rich and famous people don't sue the regular public. Because that's beneath them. Why would I pay all this money for lawyers when I could just simply ignore it? Because you know why? Because it was costing money and people were starting to believe it. And here's the thing. Cardi B was still an up-and-coming artist. She was still new. So people probably would be like, well, I don't want to, you know, have this woman wear my clothes if she have herpes. I can't have her in a movie because, you know, she did that movie with J-Lo, the other women, Constance Wu. I can't think of the other women though. But she did that movie where she was playing an exotic dancer and she had come from that background. What if people like, I can't kiss her because she got herpes? It adds up. I don't want to work with her. Not because I don't like her, but I got to protect my health. So Cardi B had to do that. She had to sue her, but it's not about the money because she's like, listen, lower the account to $75K. She could have easily said, I want at least $5 million from her. But she knows she don't have it. Tasha K's net income, according to YouTube, from like 2020, it was only about $64K. It was only $64K, which is like you know, lower middle class income, but still, it wasn't that prestigious, being that she does all the mess on YouTube. But Cardi B couldn't afford for somebody to mess with her money and her reputation. That's why she did it. So now, because of all of this, this is why I said YouTube is going to go hard on all of us. Notice how people are stepping away from all the controversy. Like, I'm not going to talk about this YouTube. I'm not going to talk about that YouTube. Even though non-famous YouTubers. Because we all got to be careful. Because, yes, freedom of speech is the very first amendment and the very first thing on the Bill of Rights in the Constitution. But guess what? You can't libel. You can't commit slander. You can't commit any of that. And where the libel comes in, they recorded it and then put it on freaking Twitter in terms of Tasha K. And was asked over and over, take it down, take it down. This whole case could have been prevented. She could be popping bottles celebrating 1 million right now. But she got the 1 million, but she in court. That's how whack your game is, Tasha K. I said it. And nobody's going to want to touch Tasha K. She's going to be in that cellar. She'll be doing videos. Because like I said, I don't think they're going to take her YouTube channel right away. And she got the internet channel and she got like the app too that she's creating. She'll be in the cellar. But she ain't going to be in no studio on NBC, ABC, CBS, Fox News. Nobody in the entertainment industry is going to want to touch her. Nobody in media is going to want to touch her because she is tainted. Lawsuit. You work with her, you'll be attached to a lawsuit. YouTube, even though they're not being sued, because this was done on their channel, Google ain't going to want to deal with her. They're not going to promote her channel anymore. Yeah, she got the gold plaque for 1 million, but I bet you they're not going to promote her channel to even get to 100 million. No, I think it's 10 million. To 10 million. The diamond plaque. Yeah, the diamond plaque, the 10 million. And definitely not even the 100 million, which is the red diamond. No, they're not gonna do that. They're gonna make sure her channel she stays at 100 million, but she'll always be in that million club because they can't afford to be attached to Tasha K, the woman that ended up being sued by Cardi B. This is not a good look for YouTube either. And in closing, I want to say this. When I came to YouTube, I was definitely on the current events tip. I was going to do that. But my whole goal was to do 2 other channels. Of TV reviews, a review channel dealing with TV, movies, music, books, and even like different like specials on TV. Just reviewing different forms of entertainment. And I was supposed to be doing a legal channel. But things got side up and switched up for me like almost 4 years ago. So I just stuck on the other channel. My channel, I got, switched over to the what they call, not the beef sector, but the dirty sector YouTube, which I don't think is fair to really call it that, because I think that's just grimy in itself. We know who coined the term. We're not going to go there with that because I'm not going to mention his name on this. But what I will say is that for me, this whole thing has caused me to want to go more into doing my channels, doing reviews, more and doing like legal history and politics. Because I noticed that when you talk about stuff like that, you don't get caught up in controversy. But when you talking about like everyday matters with entertainers and their personal lives and like the YouTube people, it's like you get caught up in BS and then the algorithm pushes you to where it's like you're open for attack. I've gone through experiences like that, but I know what to do and what not to do now. So henceforth, I'm going to be building up my 2 other channels. This one and my review channel. I'm going to still be on my main MsAnalytical channel, but I'm definitely going to only deal with like current events on that one. The only YouTubers I will talk about are like the big name YouTubers, but I'm not anything that's going to cause controversy. I'm not getting involved in it. And I want to give a shout out to Armand Wiggins because this man has greatly provided details about this case because he got screwed over by this woman. She tried to ruin his brand. I want to give a shout out to Choke No Joke. He's been at the trial known as Dennis Byron from Hip Hop Inquirer. They've been on it covering this live. Also, I want to give a shout out to all the YouTubers who, just like me, called out Tasha K's antics and wanted it to stop, and it never got stopped. And we were called haters by the winos. And we have now been officially vindicated. And thank you for that. We got to thank ourselves for that because we did our thing. We really did. We never got caught up. We saw what the BS was. And the winos, I'm going to tell you, the winos, I don't even think her fan base is as big as it was back 4 years ago. Because now with this whole trial, the winos ain't going hard. The winos, I think they acted as if they in rehab. Because they drunk the wine so much, they was real intoxicated with her nonsense. And now you don't even see them defending her. And that's something that Tasha K really got to look at. And you know, Tasha K is walking in real humble, real quiet. That internet persona, totally different from in court. Even when she's walking outside, she's very quiet. Because outside of all the cameras, the wine, and Teddy, she's quiet. She don't have a fight really in her. But I am going to talk about the perjury case. I'm going to do research on it. I'm going to talk about that because I think that's extremely important to know. Because if they find out that she really perjured herself, you will definitely go to jail for that. Or she'll have to pay a fine as well, or both, or not. Who knows? But also, Cardi B about to be in the history books, and Tasha K is going to be infamous. And Star Marie, she'll probably pop back up once all this is over. You know, it is what it is. But, yeah. You know, so I want to thank all of you all that listen to this. I want to give a shout out to not just the people that post the legal papers. I'm going to post a link to that. But also, I want to give a shout out to myself because when I first saw that it was 30 pages, I really didn't think I could read all of that. But I really did. And, you know, this has really inspired me to really get back in the game in the legal profession and to really, like, apply for jobs in law offices. Like, I really want to get back into the game of this. Like, OMG. Like, I really want to so bad. Because this is the profession I'm supposed to be in. You know, I love my YouTube and all, but I can't stand, like, what I'm doing right now. In terms of, that's a whole nother story. I'll probably talk about it in a couple of months down the line. I can't right now for legal purposes, but it's not criminal. It's like civil and stuff. So, yeah, but basically, this is just remarkable. And to see Tasha K losing the way she is, it's embarrassing. You know, and as a black woman, you know, Tasha K is, like, I'm a quarter Hispanic. But I'm 75% lineage, foundational black American. So is Tasha K. And I want to end on this note. Tasha K, what you did a disservice to us as a community. And you did a disservice to the brand of ADOS. And I'm going to talk about that on this channel. Because what she did, she was trying to do like a whole thing about Hispanics versus blacks. And that black women were disrespected by Cardi B. No, that ain't it. That shit ain't gonna bring Tasha K. But in all, the brand is done. It's a wrap for the Unwind with Tasha K brand. She lost. Just pay up the money. And with that being said, it's your girl, MsAnalytical. I'm signing off. Thank you for listening to the first commentary on my law, history, and politics channel with MsAnalytical. Talk to y'all soon. Later.